Hello everyone, my name is Anup Nair. I am representing group number 44. We are here dealing with the case Kokotovich Constructions Private Limited versus Wellington. Uh, this was the court case which was held in NSW court. It is one of the very rarest cases, and that is why we thought of taking this case up. We are very thankful to our lecturer, Mr. Jonathan Temporal, for allowing us to choose this topic. Our group consists of me, Anup Nair, and then we have Rishabh, we have Srinivasa Balaraju, we have Hamad Hamid, and then we have Naim Sheikh. So I'm gonna explain you a brief introduction of the case. There are three main parties in this case. One is Kokotovich Constructions Private Limited, and then the other one is Mr. Nicholas Kokotovich, and the third one is Mrs. Elaine Wellington. The story goes where Mr. Nicola Kokotovich and respondent Mrs. Elaine Wellington, which lies the heart of this case, their relationship extends to over 20 years. To 1962. The relationship was at times in the past an intimate one. For most of the 20 years, Mrs. Wellington worked for Mr. Kokotovich. However, these close ties have now been broken. They always maintained a de facto relationship until Mr. Kokotovich got married in 1973. Mr. Kokotovich tried his best to limit the extent of this relationship. In his evidence, it is clear that there was at least a sexual relationship between the two of them. Mrs. Wellington assisted Mr. Kokotovich with his farm working business during the period. Eventually, she also left her railway job and then became a full-timer at this company. Mrs. Wellington also testified that she prepared quotations, wrote up the books, and performed other administrative tasks. There was some evidence that Mrs. Wellington also supplied money to the business, but Mr. Nicola Kokotovich denied it and said that they were only taken as per loan and which were also repaid to her. They had What Mr. Nicola Kokotovich did later is that he incorporated the business into two, and one was the Kokotovich Constructions Private Limited, which is also the first appellant, and NK Plant Hire Private Limited, which has since been placed in liquidation. The events surrounding the incorporation of Kokotovich Private Limited are central to the issues in the case. In his evidence, Mr. Kokotovich emphasized that in forming the company, he always intended to keep the business under his sole direction and control. He testified as to the existence of conversations to that end with Mr. Robert Bullivant, the accountant employed for the purpose of the incorporation's procedure. Kokotovich Constructions Private Limited was incorporated with Mr. Kokotovich holding one governing director's share as well as one each of the A and B ordinary shares, and with Mrs. Wellington holding one A and one C ordinary share. Mr. Bullivant testified that he had told the second appellant that he would need a second person to be a shareholder. He was advised that Mrs. Wellington would be that person. Mr. Kokotovich claimed that he stressed to Mr. Bullivant that the business was his and his alone, and that Mrs. Wellington only held shares so as to satisfy the legal requirements. Both Mr. Bullivant and Mrs. Wellington denied that these words were ever said. After the companies were formed, Mrs. Wellington continued working for the business in a largely administrative capacity. It appears that at times she also maintained close personal contact with Mr. Kokotovich and members of his family. However, these family relations began to break in the early 1990s. On May 9, on 12th May 1992, Mr. Kokotovich asked Mrs. Wellington to go to the office of a firm of solicitors with the first appellant's company seal. She refused to do so. Only 13th May 1992, Mrs. Wellington received notice of an extraordinary general meeting of Kokotovich Constructions Private Limited, which was to be held on 9th June 1992 to consider a special resolution to remove her as director and secretary of the company. She was in fact removed from office at that meeting. Then on December 10th, 1992, Mr. Kokotovich convened a meeting at which he purported to issue a further 9,795 $1 shares in the first appellant company. The validity of the share issue is in the question in these proceedings. Okay, there are four main issues in this case which were briefly looked upon by the owner. One of them, the first one, was who beneficially owns the shares in the first defendant. That was the first issue that the judge was looking after. So here's what he concluded. In all the circumstances, it was intended at the time of the formation of the company that Mrs. Wellington should have a beneficial interest in the company, not because she had made any great financial contribution, but in recognition of her emotional relationship with the second defendant and the time that she had spent in the affairs of the company. The second issue was should any order be made rectifying the initial allotments. So the judge very well concluded that his discussion of the issue by noting that the A class shares, which were the only validly issued shares, conferred voting rights but no rights to participate in or receive any dividends, profits, receipts, and distribution of surplus assets. Therefore, if the issue of the other shares were not validated, and the holders of the A class shares did not alter the articles of association, the property of the company on winding up would pass to the Crown as bona vacantia. The fact provided a further reason for validating the shares as asked. The third issue is the allotment of December 1992 actually valid? So in that also the judge had to look after a lot of claims, and then he had to actually reject the claim by Mr. Kokotovich that there was no fiduciary duty owed in the circumstances. Therefore, His Honor considered that the allotment made in 1992 had been made for an impermissible purpose. He declared it to be invalid. The final question came, which was a very tough one. Should the company be wound up? It was very carefully noted that the company did not itself conduct a business and simply owned a piece of land. Young J, that is the judge, came to the conclusion that winding up is as good a way as resolving the present conflict in any other. His Honor therefore ordered that the company be wound up and that an official liquidator be appointed to conduct the winding up. However, young J stayed these orders to give the parties the opportunity to settle the dispute by negotiation. Last, they failed to do so. aspect that we look upon is what the duties and responsibilities breached, and we understand that there was a breach of Section 54 of the Act. The court held that the allotment of Class A shares falls within the provisions of Section 54 as the shares were subscribed. The court submitted that when the shares are to be allotted, then it is necessary that apart from subscription, there must be an application by the shareholders and a director's resolution to allot the shares is needed. Nevertheless, this procedure was not followed, hence violating Section 54 of the Act. There was also a violation of fiduciary duty. It was found that the second appellant has violated his fiduciary duty by issuing shares which has hampered the voting rights and the powers of the respondent, that is Mrs. Elaine Wellington, and the acts are considered oppressive in nature. The other important fact that we have to look upon is to see what the courts decided and what was their decision, and we need to analyze that, and we also need to know the reasons compared to what the Corporations Act were. The courts are circumspect in making winding up orders in circumstances where the complaint is one of the oppression. In Kokotovich Constructions Private Limited versus Wellington, the Court of Appeal held that the winding up of a successful and prosperous company is an extreme step, one requiring a strong case. The judge argued that the plaintiff had beneficial interest in the company not because she contributed financially, but because of the emotional attachment with respondent too. It was clear that the two had sexual relationship. Besides that, the plaintiff had asked that the invalidated issue of shares in 1972 must be validated as per the section 194 of the Act, submitting that the court is empowered to validate any order where the order is perceived to be just and equitable. The judge in his ruling held that there was no technical defect that can be assumed on the part of the defendant while catering his power as governing director, noting that the raising of capital in 1992 was not raise money, but to make sure that no proprietary right must be acquired if any plaintiff becomes redundant. The allotment was hence declined. Based on the ruling, the judge argued the best approach to resolve their differences was to issue a wind-up order. Thus, we can conclude that the decision under Kokotovich Constructions Private Limited versus Wellington is a landmark decision. It gives a strong impression that the duties of the company director must be complied within each and every scenario. No excuse can be made, and the directors of the company cannot shed away with their duties both under common and statutory law. If any company director does not wish to comply with their duties, then the courts are not reluctant and are willing to dissolve the company. That's it from us. We hope that we have served well by taking up this case. We got to learn how the cases can take their twists and turns in real life. These real life experiences can help us in the future. That's it, folks. Thank you very much.